Welcome all, my dear friends. Let us enter into another significant arena of the world of patents, that is known as patent drafting. So, after having a lots of discussions on the most significant sections, rules, and forms of the Patents Act 1970 and the Patents Rules 2003, respectively, let us enter into this beautiful and most important arena of the world of patents. Okay, so let us continue with patent drafting. Fine. So, patent drafting or otherwise we can say patent specification writing. Okay, and today I have taken the topic patent specification. Okay, so let us proceed with this. Now, a beautiful thought, friends. Just listen it carefully. Grasp the essence from the seed and let it drip from your fingertips. I'm again reading it, friends. Grasp the essence from the seed and let it drip from your fingertips. And that's called drafting. I hope it is clear. Fine. That means I have tried to explain you the storm drafting in a literal way with showing some beautiful clips. Fine. I hope you get it. Okay. So let us proceed. Now we will have a comparison because whenever we say what is a draft, normally we go to its literal meaning. Fine. So first of all, we will go to the literal meaning of a draft. Fine. Okay. We can say that a draft is a preliminary version of a piece of writing. Fine. Or it is or we can say a draft is a written order to pay a specified sum. Fine. So this is the normal and literal meaning of draft. Now we will go towards what is a patent draft. Fine. Because this is the demand of our legal world or the world of patents. Fine. Okay. Let us see. A patent draft is a technical document presented in a legal format that has two primary functions. Fine. Number one is to establish novelty, and point number two is to establish inventive step or non-obviousness of an invention. Fine. Also, we can note it that patent drafting is the process of writing the patent description and claims. Fine. When the patent is issued, the draft is the specification part of the document. So, whenever you will try to understand the meaning of this statement that I have written in the note part, then your confusions will be clarified. Fine. So, just remember, patent drafting is the process of writing the patent description and claims. Fine. And when the patent is issued, the draft is the specification part of the document. Fine. So, the comparison has been done. Let us proceed. So, friends, continuing from the first part of FER, let us try to complete the rest parts. Okay. So, the title for the first slide here is Responding to the Patent Examination Report. That means we can also say responding to the FER. Fine. Okay. So, if you have received an adverse report, usually it is because the application does not meet the requirements under the Patents Act. Okay. That means if the patent applicant receives an adverse report. Okay. Adverse report means this is not as desired by the patent applicant, right? And why this happens? This is because the application does not meet some of the requirements under the Patents Act. Fine. So why does this happen? Okay, let us try to dig a little deeper and try to know what may be the common objections in the next slide. Fine. Okay. Some common objections. That means if the patent applicant receives an adverse report, what may be the common objections? Fine. So let us read one by one. Point number one, the invention lacks novelty, inventive step, and or industrial applicability. That means the patentability criteria are lacking here. This may be a reason for the objection. Fine. Point number two, the subject matter of the invention is relating to a category which is not an invention as per section 3 or section 4 Patents Act 1970 that you know. That means what is section 3 and section 4 about? Fine. Point number 3. The claims are not written correctly and do not describe the elements of the invention. That means lack of clarity we can say. Fine. Lack of clarity and correctness as well. Fine. That means these are not written correctly and they don't describe the elements of the invention. Description is also not up to the mark. Fine. The next point. The claims are inconsistent with what is described in the specification. Okay. That means there is a mismatch between the specification and the claims part. Fine. Okay. Next point. The claims are written poorly and are unclear. Okay. That means clarity is lacking. The next point. The claims describe more than one invention, which is not allowed. Fine. And the next point is there is non-fulfillment of any other requirement under the Act. Okay. So this may be some common objections. And that's why the applicant receives an adverse report. Fine. So friends, no one is 100% correct, right? So if the patent applicant finds that the objection is unreasonable, okay, that's why the uh, title for this slide is what if the objection is unreasonable. Fine. So let us proceed with this. Point number one. If you think that an object is unreasonable, you can ask the examiner to withdraw their objection. That means these are the rights of the patent applicant. Fine. Point number two. You can do this in situations where you believe the examiner may not have understood your invention or parts of the invention. Okay. May not have understood your invention as a whole or part of the invention, or where you believe the examiner has not applied the law correctly. This may be the situations. Fine. Point number three, you can send a letter to the examiner and make sure it includes details as to why the objection should be withdrawn. You can write it. You can write a letter to him. Fine. The next point is if the objection is withdrawn, you will not have to amend your application. That means amendment here is not necessary if the objection is withdrawn. Fine. Okay. Okay. Now, the title for this slide is why is the examination report reply? So, here is the keyword is arguments that are weak. Okay. So, if an application is well drafted but the arguments to the office action are weak, then it can ruin the potential innovations protective rights. Fine. So that's why the examination report reply is really important. Also friends, our practitioners are technically strong and trained to craft technical arguments based on the laws guided by patent laws around the globe. Fine. That means the practitioners really keep it in their mind that drafting should be 100%. That means drafting should be weighted in every dimension, it should be of a top quality. Fine. That's why, keeping this in mind, that the examination report reply is so important, the practitioners act is required. Fine. Okay, let us proceed then. Types of replies. Types of replies. Okay. A template is followed to begin drafting a response that keeps things accurate, fast, and efficiently punctual. That means these three criteria are so much essential, we can say. Pretty essential, we can say. Fine. The next point is things that need to be considered and focused on during an examination report, or we can say things that need to be considered and focused on during an examination report reply. Drafting become very technical or just plain simple legal procedure compliance issue. Fine. That means we can say the things to be considered and focused during the examination report reply, and drafting is very much technical or just a plain simple legal procedure compliance issue. Fine. Okay, let us proceed. So we can say type 1, or there are two types of replies. One is procedural. Okay, if the objection is related to a procedure that the Patents Act 1970 demands, then the applicant has no choice but to comply with taking necessary steps. For example, when there are several noble subject matters, the unity of invention needs to be identified, and because an application may have only one noble subject matter, another application may be filed for each new subject matter. Okay, by reading this example, you can be pretty much clear about this procedural type of reply. Fine. Next one is technical type of reply. Okay, technical objections can be countered by arguments. Okay, if there are any objections as per the technicality, or we can say that there are some technical objections, then it can be countered or opposed by arguments. Fine. A few steps can be followed in case of technical arguments. See, point number 1, it has to be identified whether the arguments in the reply will be based on the original claim set or amendment is required. Fine. That means it has to be watched. Fine. Further, amending claims if required, keeping in mind cited arts, whether it predates the patent application filing date or not. Okay, that means this thing must also be considered while amending a claim. Fine. Point number 2. In case of objections relating to novelty and obviousness, the technical differentiation with respect to prior art needs to be brought out. Fine. So it has some more points, sub points we can say. So bit 1 says novelty is a subject of facts and arguments are, just read it again. Novelty is a subject of facts and arguments are based on eye to eye analysis and is subjective. Fine. So the only thing that can be done is to explain own invention in a better manner. That means we can say this is the right option to explain own invention in a very good manner or a better manner, we can say. That means more clearer way or a better way. Bit number 2. Obviousness arguments are generally based on point of law which involves determining difference between the prior art and present claims. So when the arguments are based on the obviousness, okay, so these are generally based on point of law which involves determining differences between the prior art and the present claims. It has to be explained that the prior arts and the differences in combination do not reach to the invention, and the documents cited by the examiner cannot be combined by a person skilled in art. Doing a technical study and exploration to a point of scrutiny helps in drafting an appropriate legal response to the examination report. That means these are the so many things that to be kept in mind while giving a legal response to the examination report. Fine. I hope it is. I hope both the types of replies are pretty much clear now. Okay, friends. So please go through each and every slide of this video lecture. And with this video lecture, actually, the FER part is completed. That means FER part 1 already we have discussed, and this is part 2. So as a whole, we can say that FER is completed. So please go through this. If you have any queries, please put them down in the comment box. Happy learning, friends. So friends, enrich your brain cell with proper food and proper knowledge. So thank you all, my dear friends, for listening to me and watching my video. Please like, share and subscribe my channel. Please keep questioning. Please keep learning and keep enjoying. Thank you so much. God bless you. Jai Hind.